10 seconds, 10 seconds, 15 30 seconds. So, dear friends, so you are quite familiar with the quiz. Quiz is something odd, eccentric, unexceptional. Okay? So, we prepared that questions will be very odd. Sometimes questions may be simple, questions sometimes may be very odd. So, in quiz, there is always an element of luck factor because of the bonus marks. Okay? So, anything is a competition. Competition, there are winners and losers. Okay? So after life is a blend of failures and success. Okay? So the rules of this quiz are: we start with clockwise direction, and the first question will be put to the first team. If the first team is able to answer that question, then the next question will be put to the team number 2. Suppose for any reason, if the team number 2 is unable to answer that question will be passed over to the team number 3. If team number 3 is able to answer that question, and because the answer made by team number 3 is a bonus answer, so again the question will be put to team number 3. Okay? So the process goes on like that until the end, that is until the 19th team. Then we start with the anti-clockwise direction. Okay? But the last round will be rapid fire round. The rapid fire round, there is no bonus. So if the question will be put to, so the team number 1, if it fails to answer, then it stops there itself, because the last round will be practical questions, which will be which aim at assessing the reasoning and application skills of the students. Okay. So the quizmaster acts like the apex court. Sometimes the quizmaster may even be vulnerable to fault, but you cannot question. Okay? If you have any, if you want to disagree, then you can disagree outside, but not in the here. Okay? Audience, you too have the prizes. Okay? But audience, but don't use mobile phones. Okay? So for right answer, the team answering will be given 2 marks. For wrong answer, you will be given -1. So be careful, cautious, diligent and circumspect in answering. If you are sure, then answer. If you have any kind of diffidence, hesitation, better not to answer. Okay? So with this, shall we start? Okay. So sometimes you may give a part of the answer. In such a case, the quizmaster acts like the Supreme Court. Whether to give marks or not depends upon the discretion. Okay? So the Constitution is the fundamental of the land. Every law derives from the Constitution. It acts like a grand now. So as usual, we start with Constitution.
Number 1. Question to 1.
Question to team number 1. We start with the clockwise direction.
Plateau.
Question to team number 1, Plato. The Constitution of India was handwritten in English language in the Italian style by a renowned calligrapher. What is his name? The Constitution of India was written in handwriting by a renowned calligrapher without taking a single penny from the government of India. He is a renowned calligrapher. In fact, Jawaharlal Nehru has offered to pay handsome amount, but he said, "I'm well off. I don't want to take a single pie." What is the name of that calligrapher? The first version of the Constitution of India was handwritten by a renowned calligrapher in Italian style. What is his name? Team number 1. You will be given 25 seconds maximum. For Passover, the time for original, for the team to which the question is put, 25 seconds will be given. Team number 2, 3, 4. Prem Bihari. There is one word is missing in between. Prem Bihari. Prem Bihari Narayan Raivoda. Yes. Marks to team number 5. Team number 5.
2 marks.
Now question 2. Team number 2. So we say that the US Constitution is perhaps one of the shortest constitution. But when US got independent, they had only 13 states. They come out with a constitution, first constitution. Later it was repealed and they come out with a different constitution. What was the first name of US Constitution? What was the first name of US Constitution? Now we say Constitution, but originally the US Constitution was not called as Constitution. It had a different name. Okay, what was its name? What was its name? Two, three, yes.
Declaration of Independence.
-1, 4, 5, 6, 7.
Bill of Rights.
Minus Bill of Rights is fundamental rights. 9, 10,
11,
11,
12, 13, 14, 15, 16, 17, 18, 19, 1.
1.
Audience.
Audience. The Articles of Confederation. The first Constitution of United States of America is popularly known as Articles of Confederation. Next. So Articles of Confederation. Next. Question 2. So, how many times the preamble of the Indian Constitution, how many times the preamble of the Indian Constitution has been amended until now? Until now. How many times the preamble of the Indian Constitution has been amended thus far or so far? How many times the preamble of the Indian Constitution has been amended thus far?
Twice.
Minus?
5 times. Minus.
Twice, 2 times. No. Minus?
Twice or twice? Twice.
Minus?
5.
Only once in
Yes,
42nd
only
amendment.
once. 42nd Amendment. Only once, yes. Only once. Next.
4. All.
See, when the Constitution was drafted, every part of the Constitution, before its beginning, had a pictorial diagram. Example, for the fundamental rights, the pictorial diagram was drawn. For every part, there was a pictorial diagram depicting the history, mythology, and these pictorial diagrams were drawn by an eminent artist from from Rabindranath Tagore, from Vishwaniketan. Okay, what is his name? So every part of the Constitution begins with a mythological depiction, a mythological portrayal, or a historical portrayal, and a famous artist from Rabindranath Tagore University, Santiniketan had drawn those pictures. What is his name? What is his name?
5,
5, 5,
Nandan Bose.
huh?
Nandan Bose.
Nandalal Bose. Yes. Yes.
okay, 5.
Next.
5. Update.
Question to came up 5. So the Constitution of India was drawn by 385 members, out of which how many were women? How many women members were there in the Indian Constituent Assembly?
6.
6.
15.
Huh?
15.
Yes, 1-5. 1-5.
6. Next question.
So we have a basic structure doctrine which says the power of the parliament is limited. The parliament cannot alter, amend the basic framework of the Indian Constitution. But this basic framework doctrine was for the first time propounded by a German professor. The German professor, while delivering a lecture at the Banaras Hindu University, Varanasi, said that there are certain features of the Indian Constitution which are immutable and they are beyond the power of the parliament. Who is he? What is the name of that professor? So the basic structure doctrine actually was enunciated by a German professor, and from that the Supreme Court had taken the cue. What is the name of that professor?
7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19.
1,
1, 2, 3, 4, 5. Audience.
Audience. Audience. It is a Dieter Conrad. Dieter-Conrad. Dieter, Professor Dieter Conrad was the German professor who for the first time came out with the basic structure doctrine. Because Germany had a bitter history of the Hitler taking over and nullifying the constitution. So taking a cue from the German history, he came out with the concept of basic structure doctrine. Next.
7.
7. Who, there is a famous member of the Indian Constituent Assembly, and according to him, the preamble of the Indian Constitution is a political horoscope. He described the preamble as a political horoscope. Who was he? There is a renowned member of Indian Constituent Assembly who described the preamble of the Indian Constitution as a political horoscope. Who is he?
8,
6.
9, 10, 11, 12, 13, 14, 15, 16.
A.M. Munshi.
Yes, K. Munshi, yes. K. Munshi. K. Munshi, yes.
8. Next question to 8.
8, we have some odd laws like BNS, Bharatiya Nyaya Samhita, Bharatiya Nyaya Suraksha Samhita, Bharatiya Saksha, Adhiniyam, and these words are quite incomprehensible, and these words are very difficult to pronounce, and in fact these laws have been named in Sanskrit, though there is a provision in the Constitution. There is a provision in the Constitution which explicitly says that the language of the Supreme Court, that the language of the bills introduced in the Parliament shall be in English. What is the name of that article? There is a specific article in the Indian Constitution which says that the language of the Supreme Court and High Courts shall be in English, and every bill to be introduced in Parliament shall be English unless and until the Parliament by law makes otherwise. What is the article? What is that article? What is that article? Or what article of the Indian Constitution says that the language of the Supreme Court and High Court shall minus
17, 18, 19, 1, 2, 3, 4, 5, 6, 7, 6.
340 each of the constitution.
Yes, 348. 348 of the Indian. 348 of the Indian Constitution.
9. Next question to 9.
Question to team number 9. So, who is popularly known as the father of the US Constitution? Who is popularly known as the father of the US Constitution? Who is popularly known as the father of the US Constitution? He is also one of, I am also giving the cue. He is also one of the authors of the Federalist Papers, which was at the foundation of the US Constitution. The Federalist Papers are the foundation of the US Constitution, and he was one of the authors of that Federalist Papers. Who is he? Who is popularly regarded as the father of US Constitution?
10. 11, 12, 13, 14, 15, 16, 17, 18, 19, 1, 2, 3,
minus
up to 8. Pardon?
what? No.
5, 6, 8 వరకు 8 వరకే ఆడియన్స్
Who? Yes. Minus, double minus. James Madison. James Madison is popularly regarded as the father of US Constitution. James Madison. Next. Look, సరిగా pronounce చేయాలి. You have not pronounced it properly.
ఓకే రైట్
James Madison.
10 క్వశ్చన్ నెక్స్ట్ క్వశ్చన్ టు 10
Next.
10
Then, so Schedule 8. Schedule 8 of the Indian Constitution recognizes 22 languages. I know, I think, I perceive that you are quite obvious, despite known to anyone. Schedule 8 recognizes 22 languages. And out of these 20 languages, certain languages are not the official language of any state. How many such languages are there? Schedule 8 of the Indian Constitution recognizes 22 languages as official languages. Out of those 22 languages, certain languages are not the official languages of any state. Even then they are recognized. And how many languages are there? How many languages are there?
7.
7 minus 7.
13, 14, 15, 16, 17, 18, 19, 1,
Minus
up to 9. 9 వరకు 9 వరకే
8 languages. They are Bodo, Dogi, Konkani, Maithili, Sanskrit, Santali, Sindhu and Urdu. 8 languages. Okay, next.
11.
11. The preamble of the Indian Constitution begins with the words, "We the people of India." We the people. The first 3 words are borrowed from a particular constitution. Name the constitution. The preamble of the Indian Constitution begins with the words, "We the people of India." We the people. These 3 words are specifically borrowed from a particular constitution. Name the constitution.
Twelve, 13, 14, 15, 16, 17,
Canada.
Minus.
18,
US Constitution.
Yes, US Constitution. US Constitution.
12,
Which schedule of the Indian Constitution deals with provisions pertaining to administration of scheduled areas? Which schedule of the Indian Constitution deals with provisions pertaining to the administration of tribal areas?
5th schedule.
Minus.
13, 14, 15, 16, 17, 18,
6th schedule.
Sixth schedule. Sixth schedule is the correct answer.
13,
13. So part 4 of the Indian Constitution deals with directive principles of state policy aimed at establishing a welfare state. But there is a famous member of the Constituent Assembly who said, I quote, "Directive principles of state policy are like a blank check drawn on a crashing bank, drawn on a bankrupt bank." Who said it? So, who said directive principles of state policy are like a blank check drawn on a liquidated bank? Who said it?
14, 15, 16,
Katie Shaw.
Yes, Katie Shaw, right? Katie Shaw.
14,
Next. 14. When Constitution was enacted, how many articles, schedules, how many articles and schedules parts were there? When the Constitution was first adopted, how many articles, schedules and parts were there? So you should specify how many articles, how many parts and how many schedules.
pass. 15,
395 articles and 22 parts, 8 schedules.
Yes. Yes.
15, next question.
Next. Who said about Indian democracy? Which of the famous personality of the Constituent Assembly said about Indian democracy, saying, in India, democracy is yet to root. In India, democracy is a hollow. In India, democracy is only top trust, and it has to get down to the grassroots. Who said? Who said? Who made the famous quote? In India, democracy is only top trust, and it has to go down to the masses. Who said it?
16. 17, 18, 19, 1, 2, 3.
Yes, Dr. B.R. Ambedkar. Yes. Dr. B.R. Ambedkar.
16.
The question to 16. Who said, there is a famous US Supreme Court judge who said, I quote, a lawyer who doesn't have basic understanding of economics and sociology, he will apt to be a public enemy. Who said, a lawyer who doesn't have knowledge of sociology and economics would turn to be a public enemy? Who said? A lawyer who doesn't have understanding of sociology and economics would turn to be a public enemy. Who said it? He's a famous US Supreme Court judge.
Pass. 18, 19, 1, 2, up to 15.
Justice Learned Hand.
Minus.
Up to 15. Audience.
Yes, Justice Brandeis, Louis Brandeis, one of the renowned US Supreme Court judges.
First year ఎవరు? First ఎవరు వాళ్ళు?
So we colloquially say Dr. B.R. Ambedkar is the architect of the Constitution, but Dr. B.R. Ambedkar himself has not agreed during his lifetime. He said, my contribution to the Constitution is there, but I am not the architect of the Constitution. There is also another luminary, legal luminary, whose contribution to the Indian Constitution was gigantic. And in fact, he prepared the first draft of the Constitution. So who prepared the first draft of the Indian Constitution? Who prepared the first draft of the Indian Constitution? Who prepared the first draft of the Indian Constitution?
Pass. 18, 19, 1.
Yes, right. Right.
2 కదా?
Right.
18.
In a famous judgment, one of the illustrious judges of Indian Supreme Court has said, our tradition teaches tolerance. Our tradition teaches tolerance. Our philosophy preaches tolerance. Our constitution practices tolerance. Let us not dilute it. In which of the judgment these words form the closing remarks? What is the name of that judgment? Quote again. Our tradition teaches tolerance. Because nowadays there is a lot of hatred. And so, long back, a visionary has said, a visionary Supreme Court judge, our tradition teaches tolerance, our philosophy preaches tolerance, our constitution practices tolerance, let us not dilute it. What is the name of the judgment? The judgment is very famous. What is the name of the judgment?
Pass. 19. 1, 2.
Shirur Mat.
Order?
Shirur Mat case.
-1.
SR Bowman versus Judicial.
Minus.
Up to 70.
Indian Employer Association. Indian Employer Association.
Minus. Audience, yes, sorry.
Audience.
Yes, right. Vijay Emmanuel versus State of Kerala and others. Justice Chinnappa Reddy. Justice Chinnappa Reddy. Vijay Emmanuel versus State of Kerala and others. The judgment closes with the votes. These very particular votes. Yes. 19. So moot court semi-finals over. Some of you have some grievances, I understand. But unfortunately, judgment is never objective. Judgment is always, justice is always relative. Okay? So there is no place in this world. Please try to remember that, friends. There is no place in this world that justice is absolute. So right from Aristotle to all the scholars have emphasized emphatically, justice is relative. But there is a judge of the US Supreme Court who wrote a beautiful book. According to him, justice is not absolutely objective, and the way the judge was brought up, his likes, dislikes, his prejudices, his whims and fancies, his ideology, his peer group, his parental brought up, all these things will reflect in the judgment. So therefore, he has concluded the personality of the judge reflects in his judgment. Who is he? According to him, the personality of the judge reflects in his judgment. He is a famous US Supreme Court judge. He is renowned for his contribution to the development of law. Who is he? Who is he?
One.
Audience. Benjamin Cardozo, who wrote Legal Magnum Opus, The Art of Judicial Process, which is a very simple book containing 150 pages, but it is a legal classic which every law student should go through. Benjamin Cardozo, The Art of Judicial Process. Yes. Now he starts with the landmark, trend-setting, radical and revolutionary case laws decided by the Supreme Court. So there is a saying that the reservation in India is not working properly, and the persons who have used the reservations are continuous to take the benefit of reservation. So therefore the Supreme Court recently has come out in a judgment. The creamy layer principle should be applied even to the scheduled caste and scheduled tribes. Hitherto, presently the creamy layer principle is applicable only to backward classes. The creamy layer principle is not applicable to scheduled caste and scheduled tribes. So the Supreme Court in this case has said scheduled castes and scheduled tribes are not homogeneous group. Therefore, the creamy layer principle should be introduced even to the scheduled castes and scheduled tribes. And the judge also gave, the judge has also given an advisory to the central government saying, we have recognized the creamy layer principle. Now it is on the part of the legislature to introduce it, but the central has not acted so far. So what is the name of the judgment? What is the name of the judgment in which the Supreme Court for the first time held the creamy layer principle should be applicable to scheduled castes and scheduled tribes because they do not constitute a homogeneous group. 17.
18, 17, 16.
State of Punjab versus Ravinder Singh.
Yes, State of Punjab versus Davendra Singh and others. Davendra Singh and others. Davendra Singh and others.
18.
Yes.
18. Next person.
Next. In which of the famous cases the Supreme Court has come out with a series of guidelines almost tantamount, amounting to making of legislation in regard to inter and intra-country adoptions? In which of the famous cases the Supreme Court has come out with a series of regulations, guidelines, saying that intra and inter-country adoptions within the country and outside the country adoptions should be regulated by these guidelines until the Parliament makes the law. Name the case.
Vishaka versus State of Rajasthan.
-1. That is regarding to protection of women at workplace.
17, 16, 15.
Supreme Court guidelines on inter and intra-country adoptions.
One. 18. Audience.
Audience. Lakshmikant Pandey versus Union of India. Next, 17. In a very recent case, in a very recent famous case, the Supreme Court has held caste or religion of an accused have nothing to do with a case, and therefore the Supreme Court issued directions to the trial courts and High Court not to mention the caste of the accused in the cause title of the judgment. In the cause title of the judgment, very recent case. So the Supreme Court has given a direction to the High Courts and the trial courts not to mention the caste or religion of the accused in the cause title of the judgment. What is the name of the judgment? What is the citation of that case?
16.
What is the citation of that case?
14, 13, 12, 11, 10.
The caste or the religion of the accused should not be mentioned in the cause title of the judgment.
Dattaram, State of.
Minus.
9, 19, 18. Audience.
Audience. State of Rajasthan versus Gautam, son of Mohan Lal. Please check. State of Rajasthan versus Gautam,
16.
son of Mohan Lal.
16.
In which of the famous case the Supreme Court has held that a Hindu marriage can be dissolved by a customary deed of divorce, provided there is an established customary right to sustain it? In which of the famous cases the apex court has held that a Hindu marriage can be dissolved by a customary deed of divorce, provided there is an established customary right to sustain it, to support and sustain it? Name the case.
15, 14, 13, 12, 11, 10. Nineteen, 18, 17. Audience.
Audience. Minus. ఒక పెన్ను తెచ్చేయమ్మా. Sanjana Kumari versus Vijay Kumar. Sanjana Kumari versus Vijay Kumar.
15,
15, in the Constitution of India, there is no provision during with the curative jurisdiction of the Supreme Court. There is no provision. But the Supreme Court has come out with the curative jurisdiction of the Supreme Court in a famous case. Name that case. What is the case in which the Supreme Court has come out, has for the first time recognized the curative jurisdiction of the apex court? Name the case. The Indian Constitution doesn't contain any provision pertaining to curative jurisdiction. But the Supreme Court in a famous case has come out with the curative jurisdiction of the Supreme Court. What is the name of the case
13,
in which curative jurisdiction was recognized for the first time?
11,
Is the case related to divorce, sir?
No, minus.
No, I'm not answering the question.
You are not answering. You are eliciting. You are making a leading question so as to elicit information from me. Okay? Thank you so much. No minus.
10, 9,
Ashokura versus Rupa Ashokura.
Pardon?
Ashokura versus Rupa Ashokura.
No, reverse చేసావు case ni. Rupa Ashokura versus Ashokura. No, reverse చేసావు. Anyhow, marks awarded.
Rule 17 of Supreme Court.
14,
Next. In which of the famous case we have a, in which of the famous case the Supreme Court has categorically or unequivocally stated that consumer disputes are non-arbitrable even though there is an arbitration clause. These disputes are non-arbitrable before an arbitrator unless and until both the parties mutually agree. What is the name of that case? In which of the famous case the Supreme Court held that consumer disputes are non-arbitrable even there is an arbitration clause in the agreement unless and until both the parties mutually agree? What is the name of that case?
Vidyadrolia.
Pardon?
Vidyadrolia.
No. Minus. Minus.
nineteen,
19.
18, 17, 16, 15. Audience.
Audience.
Please, master.
Hemlata Devi versus Uday Sri.
13,
13. So pollution is the biggest problem and poverty is the biggest polluter, and our festivals are also associated with pollution. Every day we are seeing the zenith level of pollution in Delhi. Okay? To address this issue, the Supreme Court in a famous case has come out with a direction that pollution causing firecrackers should be abolished and only green crackers should be introduced. Even for cracking of fireworks, there should be some fixed hours. So the Supreme Court further held even on festival occasions like Deepavali, the firecrackers should be cracked only during the specified hours, and that too, the green crackers should be sold, not pollution causing crackers. What is the name of that case? What is the name of that case in which the Supreme Court has come out with the abolition of pollution causing firecrackers and introduction of green crackers?
13, 12, 11, 10, 9,
Pardon? -1.
19, 18, 17, 16,
Arjun Gopal versus Union of India.
Yes, Arjun Gopal versus Union of India. Arjun Gopal versus Union of India.
12,
Question to team number 12. In which of the famous case the apex court has struck down or annulled section 497 of the Indian Penal Code dealing with adultery? In which of the famous case the apex court has struck down section 497 of Indian Penal Code dealing with adultery, saying the provision of adultery is like treating women like chattels, which is against the constitutional ethos and egalitarian concept of citizenship. Therefore, section 497 of IPC was constitutionally abominable and untenable.
Joseph Shine versus Union of India.
Yes, Joseph Stein versus Union of India.
11, 12 plus.
Next,
11,
question to team number 11. In which of the famous case the apex court has struck down Rule 45 Clause 21 of the Central Motor Vehicle Rules 1989 by directing that BS4 vehicles should be sold, no BS4 vehicles should be sold after March 30, 2020, and that only BS6 vehicles can be sold after March 30th, 2020. What is the name of that case?
pass 10, 9, 8, 2, 1,
Audience?
18, రాలే మీకు ఇంకా 18,
Srinivas sir, that question is cancelled.
మళ్ళీ వాడు పెడతారు
మళ్ళీ
11 అడిగారు
మళ్ళీ అడగాలి ఇప్పుడు చెప్తారు కదా అతను చెప్పారు.
అడగాలి
Question to team number 11. Question to team number 11. In which of the famous case the Supreme Court has held that the Chief Election Commission and election commissions should be appointed by a tri-member committee comprising the Prime Minister of India, the leader of the opposition in the Lok Sabha. If there is no recognized leader of opposition in the Lok Sabha, then the leader of the majority party and the Chief Justice of India or nominee of Chief Justice. And after this judgment, the central government has come out with a law to dilute the judgment, to appoint hand-picked chief election commissioners who would be the client to the government to disturb the level playing field. Okay? So, what is the name of that case?
Anup Paranwal versus Union of India.
Yes, Anup Barnwal versus Union of India. Yes. 10. Yes. In which of the famous case the apex court has banned? In which of the famous case? In which of the famous case the apex court has said that cap panchayats, caste associations have nothing to do with intercaste marriages and their interference would not be tolerated? In which of the famous case? So in which of the famous case the Supreme Court has held that unlawful interference and intrusion by cap panchayats in interfaith and intercaste marriages is not tolerable, and therefore the Supreme Court has given a series of guidelines. What is the name of that case?
Nineteen, 17, 18, 16, sorry. 16.
Shaktivani versus Union.
Yes, Sektivani versus Union of India. Yes, Santivani versus Union of India. Yes.
9.
9. Which of the famous case the Supreme Court held? In which of the famous case the Supreme Court held? Constitution is not a frozen document. Constitution is not a frozen document. It has evolved. It must continuously evolve to respond to the aspirations and changing needs of the people. Therefore, it is a transformative constitution. In which of the famous case? No. These dicta were made by, okay. In which of the famous cases the Supreme Court held? Constitution is not a frozen document. It has evolved and it must continuously evolve to respond to the changing, to respond to the aspirations and challenges of the future generations. Name that case.
16. 15. Up to 10. 10 వరకు. Audience.
-1. Case Puttaswamy versus Union of India by Chief Justice Chandrachud.
8. Next person.
Next. So nowadays we are seeing how Enforcement Directorate, CBI, National Investigative Agencies have become the parrots, caged parrots of the government. Okay? They are being misused and abused. Even the Supreme Court has described the CBI as the caged parrot of the central government. So, but however, the Supreme Court has intervened in a famous case. The Supreme Court has intervened in a famous case saying that the CBI and Central Investigative Agency should be autonomous, independent, and they should be insulated from political interference. Therefore, the Supreme Court has given a series of guidelines for promoting autonomy of CBI and other central government investigative agencies. What is the name of that case?
Vinit Narayan versus Union of India.
Yes, Vinit Narayan versus Union of India. Yes. Next.
7.
Next. In which of the famous cases the Supreme Court has struck down? Has partially struck down, not entirely. In which of the famous cases the Supreme Court has partially struck down Section 377 of the Indian Penal Code? Partially, not in toto. In which of the famous cases the Supreme Court has partially struck down Section 377 of the Indian Penal Code? Yes, right. Marks. Yes.
6.
So we have the criminal defamation provisions from section 499 to 502 of the IPC, and the similar provisions verbatim have been incorporated into BMS. But whether these criminal defamation provisions were constitutionally tenable or not tenable were challenged before the Supreme Court. The Supreme Court has come out with the finding these criminal defamation provisions were constitutionally tenable, and therefore the Supreme Court upheld sections 499 to 502 of the Indian Penal Code. What is the name of that case? What is the name of the case in which the Supreme Court has constitutionally upheld sections 499 to 502 of the Indian Penal Code?
19. 18. 17. 16. 15. Babu up to 5.
Subramanian Swamy versus Union of India.
Right. Subramanian Swamy versus Union of India. Yes, right. Right.
5.
Next. Question to team number 5. So the Supreme Court has said that the right to die is also a part of Article 21. So later the Supreme Court has said dying in dignity is also part of Article 21. But in which of the famous case the Supreme Court said active euthanasia is not allowed, but passive euthanasia is allowed, provided there is a living will. Name the case. In which of the famous case the Supreme Court has held that right to die in dignity was within the contours of Article 21. So therefore, active euthanasia is not permissible, but passive euthanasia, when there is a living will, is definitely permissible. Name that case.
5, 4, 3, 2, 1, 19.
Aruna Ramachandra Shalimba versus
Minus. There the Supreme Court has negated, not accepted.
Common Cause versus Union.
Yes, Common Cause versus Union of India. Right? Yes, right.
4.
So, under Article 30, the right to self-incrimination, every person has right against self-incrimination. Every person has right against self-incrimination. But to uphold this principle, the Supreme Court in a famous case held that lie detector tests, brain mapping, polygraphy, these tests are not, should not be allowed unless until the accused is willing. What is the name of that case?
4.
Brain mapping, lie detector, polygraph tests should not be allowed unless and until the accused is willing to undergo. What is the name of that case?
Selvi versus State of Karnataka. Selvi versus State of
Selvi versus State of Karnataka, right? Right.
3.
Selvi versus the State of Karnataka, yes. Right. Next.
Question for 3.
Yes. In which of the famous case, this police atrocity is very common in India, and police abuse and misuse their power. They mostly surround to their political bosses instead of the people. Okay, so in order to curb and combat this, the Supreme Court said, the Supreme Court has directed the state to upload copies of FIR within 24 hours on the website of the police, and if there is no such website, then on the website of the state government, except in regard to sensitive offences pertaining to sexual offences, insurgency, terrorism offences, or under the POSCO Act. What is the name of that case?
2.
The Supreme Court has given directions to the The Supreme Court has given directions that FIRs should be uploaded on the website of the police authorities. If the police have no official website, then on the website of the state government, except in regard to sensitive offences like terrorism offences, POSCO offences, sexual offences. Other than this, all the FIRs should be uploaded within 24 hours. What is the name of that case? What is the name of that case?
Pass.
Because tomorrow if you practice, when you go along with your client, if the police authority refuses to register FIR, then you can cite this case. This is a case given by the Supreme Court as per Article 141 of the Indian Constitution. The law declared by the Supreme Court shall be binding. It operates as the law of the land.
Forward. Audience.
Huh? -1 to Hariprasad. Yes, right. Youth Bar Association of India versus Union of India. Right. Youth Bar Association of India versus Union of India. Yes, right. Next.
2.
Question to team number 2. In which of the famous case the apex court held that social exclusion of women based on menstrual status is a form of untouchability? Social exclusion of women based on their biological condition or menstrual status is a form of untouchability, which is an anathema to the constitutional values. Therefore, the court refused to permit those practices. The court further held that the court further held such practices are against the constitutional morality apart from denying the dignity of women. Therefore, they are not valid. What is the name of that case? What is the name of that case?
19.
In which of the famous case the Supreme Court held social exclusion of women based on their menstrual condition, menstrual condition or biological status is a form of untouchability?
All Indian Employees Association versus State of Kerala.
Right, yes. Right. Indian Employees Association versus next.
1.
Question to team number 1.
కేరళ అని చెప్పారా
మీరేం చదువుకున్నారు?
In
నువ్వేం చదువుతున్నావు
which of the famous cases
I got the answer.
the Supreme Court held that any law
ఫస్ట్
placed in the 9th schedule after April 24, 1973
ఓ అయితే మీరు
will
నా
be
యూట్యూబ్
subject to
లైవ్
judicial
ఎక్స్పర్ట్
review.
పద్మజ మేడం చెప్తున్నా యూట్యూబ్ లైవ్ ఎక్స్పర్ట్ అబ్బా
All the laws. So previously, any law was placed in the 9th schedule, it would be beyond judicial review. But the Supreme Court in a famous case held that any law placed on the 9th schedule after April 24th, 1973 would be subject to judicial review. Name that case.
Women Law versus Union of
Pardon? Huh?
Sorry, Women Law versus Union of
Government?
Women Law.
Minus.
17, 16.
IR Coelho versus State of Tamil Nadu.
Huh? Yes, IR Coelho versus State of Tamil Nadu. Right. Next. Clockwise direction.
1.
So if you read the newspapers regularly, if you have the habit of reading the newspapers regularly, a lot of fanfare, a rosy picture is created, saying that the government has come out with 4 new labor codes. 4 new labor codes. These labor codes are like bonanza to workers, though the truth is otherwise. Okay? So the government has repealed 29 labor enactments and in their place 4 labor codes were introduced. You should name all the 4 labor codes. If you fail to name any one, then you will be given minus. All the 4 labor codes should be named. Okay? What are those 4 new labor codes? So the government on 21st November 2025, the government has also notified the rules, has notified the draft rules to implement these laws. What are these 4 labor codes? The government has repealed 29 labor enactments, IR, Industrial Disputes Act, Bonus Act, Gratuity Act, all these acts have been repealed. And in their place 4 new labor codes have been brought. What are they?
Pass.
Code on wages, code on
Here,
Social.
code on wages here.
2019.
Yes, right.
Code on Social Security.
Yes. Year.
2020.
Oh, okay.
Safety, health and work conditions. Code on safety, health and work conditions.
Working conditions,
Working
not working.
conditions. Industrial code.
Industrial. You have now? Yes. Industrial.
Industry. Code on industry.
Okay, fine. Give the mark. Industry code on industrial relations. 2020. Again on the labor codes, new labor codes, because this is the heart of the hot potato now. So previously, if where in an industrial establishment, 100 or more workers are, 100 or more persons are employed, and if that industrial establishment decides to lay off, lock out, or close, the permission from the appropriate government is a must. Now this 100 has been enhanced, saying if in any industrial establishment, if the limit is below that, then they can freely close, freely lay off, freely lock out, government would not interfere. So the 100 has been enhanced to something higher. What is that figure? Previously, every industrial establishment employing 100 or more persons, workers, must take permission from the appropriate government for layoff, lockout, closure, retrenchment, and now it is not necessary. It has been enhanced to some higher figure. What is it?
Pass.
Yes, 300. Yes, 300, right. Now it has been enhanced to 300. 300. Next.
Three.
Next.
Proceed.
So we have a code on wages. The code on wages says that so there is a worldwide report saying that the wages of the executives have been increasing 200%, 300%, while the wages of the working class have almost become stable, because of which there is no demand, the consumption is going down. But in spite of this, the code on wages says that minimum wages need not be revised up to certain years. How many years? It says that minimum wages need not be reviewed, minimum wages need not be reviewed for a certain number of years. Previously it was 3 years. Now it says it has enhanced. What is the number of years? That's 5 years. 5 years. Yes. 5 years. Next. Again code on wages. Again code on industry relations. So it says that previously the law under the Industrial Disputes Act, the legal provision as to strike was only public sector undertakings need to give strike notice. Non-public sector units need not give any strike notice. But the new law says whether you are public sector enterprise or private sector enterprise, every industrial establishment should give notice of strike before going on strike. Without giving that notice, no strike can be. What is the period of that notice? Minus.
14 days. 4 times.
As 14 days is the right answer. 14 days, 14 days.
5.
5. So under the Factories Act, under the Repeal Acts, the inspectorate mechanism is known as inspectors. But now, the new acts have given a specific name, saying they are inspectors come dash dash. What is it? Now the inspectors are called by a different name. What is it?
Inspectors come facilitators.
Yes, right. Inspectors come facilitators, right. Right. Next.
6.
6. 6. So Supreme Court of India is the apex court. So there is a famous quote by Pandit Jawaharlal Nehru that though Supreme Court is the apex court, if the Supreme Court commits an error, there is no appellate authority. In such a case, only Supreme Court can rectify it. But there is a motto to the Supreme Court. What is the popular motto of the Supreme Court? What is the popular motto written on the Supreme Court? What is its popular motto? What is its motto?
Satyameva Jayate.
Minus? What is the motto of the Supreme Court? అయిపోయిందా అవలేదు కదా అవలేదు కదా క్లాక్ వీఆర్ కమింగ్ క్లాక్ వైజ్ కదా
ఇక్కడ వస్తాం.
సర్వధర్మ సమభావం.
నో మైనస్
यतो धर्म ततो जय
ఎతో
यतो धर्म ततो जय
That's right. Yato dharmastato jayaho. Where there is dharma, there is victory. Where there is dharma, there is victory. Yes. Next.
7. 7.
So this motto of the Supreme Court, Yato dharmasto jayaho, was taken from a particular text. What is the name of the text? This motto was taken from a particular text, from a particular popular text. What is the name of the text from which it was borrowed? Yato dharmasto jayaho.
Pass.
Bhagavad Gita.
Yes, Bhagavad Gita, right. It was derived from Mahabharata, where it occurs, this Yato dharmasto jayaho occurs in 13 times. Yes.
8.
Next. 8. So in the history of the Supreme Court, what is the first largest bench constituted? In the history of the Supreme Court, what is the first largest bench constituted? What is the first largest bench? In the history of the Supreme Court, what is the first largest bench constituted? First largest bench. I am not asking recent largest benches. First largest bench.
8. Pass on.
Kesavananda Bharati versus State of Kerala, 13th bench.
Yes, right. Kesavananda Bharati versus State of Kerala. Yes.
9.
Next. Why the Supreme Court is popularly referred to as the court of record? Why the Supreme Court is popularly referred to as the court of record? Why is it so? For that matter, why constitutional courts are popularly referred to as court of record? Why constitutional courts like Supreme Court and High Courts are popularly referred to as courts of record? What is the reason for that? What is the reason for that?
Evidence produced for the court.
No. No minus, partly correct. No minus.
10.
There is contempt of court for Supreme Court.
Minus. No minus. Part of the answer. But if any one of you attempt, then minus will be given now onwards.
And
11.
one part is for the contempt of court, and another is that Supreme Court judgments are binding on the lower courts.
No minus.
12, 13, 14, 15, 16, 17, 18, 19, 1.
They maintain the records of these records may be used as precedents. So, any course precedents can be used lower to the issue.
That is part of the answer, but not the full answer. No minus.
It's 2.
Report in the report.
Part of the answer, no. So the answer, audience, yes, sorry.
8 వరకు.
Part 1 says that judgments of Supreme Court are recorded for evidentiary value. Part 2 says that contempt can punish for the contempt of court.
There is also part 3.
No minus.
No minus.
Up to 8. Audience.
Note carefully, the judgments and proceedings and acts of the constitutional courts are recorded for perpetual memory and testimony. Besides, these records have evidentiary value and cannot be questioned when produced before any court. Cannot be questioned when produced before any court. These courts have also power to punish for contempt of court, either with a simple imprisonment for a term up to 6 months, or with a fine, or with both. So this is the complete answer. Next.
10. 10.
Then, which article of the Indian Constitution mandates that a minimum of 5 Supreme Court judges must sit together to decide any case involving a substantial question of law about the interpretation of the Constitution or any reference under Article 143? Which article of the Indian Constitution mandates that a minimum of 5 judges must sit together to decide any case involving interpretation of Constitution or any reference under Article 143? Name that article.
10, 11, pass. Pass. 1, up to 9.
Minus.
Up to 9.
Minus.
6 to minus 9. Stop. Audience.
145 class 3.
Yes, Hariprasad is right. Went to him. 145 class 3. It is 145 class 3. Next.
11.
Team 2.
11.
11. So the Supreme Court has a unique jurisdiction of original jurisdiction. No other court in India has original jurisdiction except the Supreme Court. So by original jurisdiction we mean that if there is a dispute between the central government and state governments, between the state governments and union government and some state governments and state governments, then those disputes can be referred to the Supreme Court. This power is not available to the High Courts. For example, there was a dispute between the Union of India and State of Kerala in regard to allocation of funds. The State of Kerala has invoked this original jurisdiction. Okay? So which article of the Indian Constitution deals with original jurisdiction?
Article 131.
Yes, right, 131. 131 of the Indian Constitution deals with, yes,
12.
12. So we have freedom of speech and expression guaranteed under Article 19(1)(a). Okay, but in spite of that, we don't have Freedom of Information Act or Right to Information Act until 2004. We have only enacted the Right to Information Act in 2005. Okay. So access to information was not provided to the citizens until 2004. Though such access to information is the foundation for exercising the informed choices by the citizens. My question is, what is the first state in India to come out with Right to Information Act. What is the first state in India? What is the first state in India to come out with the Right to Information Act before the Parliament come out with the Right to Information Act 2005? What is the first state in India that has come out with the Right to Information Act?
Pass. 14, 15, 16, 17, 18, 19, 1, and up to 11.
Minus.
Mark. 4.
Yes.
Got it?
No. So Rajasthan was the initiator, but unfortunately it was not the first state. The movement started in Rajasthan, true.
4, 6,
Minus.
6 minus 1.
Minus.
17 minus 1.
Maharashtra.
Minus.
Minus 1. Up to 11. Tamil Nadu.
Yes, Tamil Nadu. చెప్పారా? But your voice was not audible to me. So that question is cancelled then. No, you have to give your answer in a louder voice. ఏమా చెప్పాడా? తమిళనాడు చెప్పారా? మాకైతే వినపడలా. You said that నువ్వు తమిళనాడు మేము పూర్తి ఆన్సర్ చెప్పలా.
Sir, we have not given minus mark to 1. Means not given. Minus mark not given, no need to cancel the question. No need to cancel it.
వాళ్ళు ఆన్సర్ చేసుకోవాలి. చెప్పి ఉన్నారు కదా.
Minus mark.
చెప్పిన అమ్మాయి ఇందంట. పక్కన కూర్చున్న అమ్మాయి ఇందంట. అదే అంట అందుకని. You see, cover words, you make your answer more audible. మార్క్స్ ఇవ్వట్లేదు వీళ్ళకి. ఎక్కడి నుంచి ఆ క్వశ్చన్ స్టార్ట్ అయింది?
12 స్టార్ట్ అయింది. 10 కి ఇచ్చాడు ఎంత?
ఆ క్వశ్చన్ ఎక్కడ ఆరిజిన్ అయింది?
ఆరిజిన్ 12.
సో
ఇప్పుడు 2 మార్కులు ఇస్తున్నాం.
తీసేయ మార్క్స్ తీసేయ. They say that they had answered that question, but that answer was not audible to me. But students sitting there were saying that they gave the answer.
Question cancel there. Minus 1
Minus marks also removed for all of you.
plus only removed.
Next question to Timnam.
12. Same.
So what is the first country in the world? What is the first country in the world to come out with the Right to Information Act? In 1774. In 1774, a country has come out with the Right to Information Act. In 1774 itself, what is the name of that country?
Pass. 13. 14.
France.
France minus
15. 16. 17.
USA minus
18, 19, 1, up to 11, amma. 1 to 11.
Sweden and Finland.
Sweden, right? So it is a tricky question. What is the time limit for disposal of the second appeal under the Right to Information Act? What is the time limit for the disposal of second appeal under the Right to Information Act? What is the time limit for the disposal of second appeal by the State Commission and the Central Information Commission? It is 90 minus. No time. There is no time for disposal of second appeal. They can take any time. Okay? That is the reason why I said it is a tricky question. Okay? No time.
14.
14. What is product liability? So the Consumer Protection Act has come out with a very innovative, novel concept, product liability. Product liability is something very important which has been recognized in the American legal system 100 years back. You must be knowing about Stella Lieback versus McDonald case. Very interesting case. What do you mean by product liability? What do you mean by product liability? Under the Consumer Protection Act, section 82 to 86 of the Consumer Protection Act, new Consumer Protection Act 2019 recognizes product liability. What is it? What do you mean by product liability?
Pass.
The manufacturers are made liable for the defectiveness.
Minus? Minus? Manufacturer liable?
Manufacturers and producers are made liable.
Liable?
For the defectiveness and.
No.
Sir,
Minus?
17, 18, 19, 1.
so they have to maintain the quality standards.
No minus?
Minus.
Minus it. Minus. Minus.
Up to 13. Up to 13.
Any malfunction of the products which does not cause any liability. Any malfunction of the product which does not cause any liability.
Minus.
80 minus 1.
2 clause 34 of the Consumer Protection Act of 2019 defines product liability as the product manufacturer, the product seller, and the service provider in case of any defects in the product.
Minus.
90 minus 1.
Minus.
Up to 13. Audience.
Product liability is a very innovative concept where a manufacturer.
Section 82 to 89, sir.
What is it?
Manufacturer, service provider, and seller are liable.
No, I am asking what is the idea behind product liability. I am not asking provisions. So product liability is a very innovative concept. In product liability, a manufacturer would be liable irrespective of his negligence, irrespective of the defect. You may ask how. For example, for understanding this, you need to understand the Lieback and McDonald case, where a lady purchased hot coffee, and while she was driving in a car, she was sipping the coffee. Unfortunately, coffee spilled over her body, and she filed a suit. Her contention was, it was described as hot coffee, but how the coffee was hot was not specified. Had it been specified, she would have been more careful, cautious. So the court said, this case comes within the product liability. And in product liability, the manufacturer would be liable, even though the manufacturer is not negligent. Okay? For example, the manufacturer has not given proper precautions about the usage of the product. Product is okay, but the manufacturer has not given the proper precautions as to usage. Then it comes under product liability. Next.
15.
Question 15, number 15. So Indian Contract Act is the basic law. Okay? So it has its foundations on every branch of law. How many types of performance are there under the Indian Contract Act? How many types of performance of a contract are there under the Indian Contract Act? And what are they? We have to answer both. How many types of performance are recognized by the Indian Contract Act? And what are they? How many types of performance of a contract are there?
Pass. 17.
How many types of performance of a contract are recognized under the Indian Contract Act? And what are they?
18. 19. 1. Up to 14. 11.
Try to
Full performance and partial performance.
no minus. But terms అనేది when law describes a particular word in a particular manner, we have to come out with the exact terminology. Okay? No minus. 2 is correct. No minus.
Five.
Actual and partial performance.
Actual performance. Sir, can you question?
Performance are recognized under the Indian Contract Act, and what are they?
Actual and partial.
No minus.
6.
Actual and part performance.
No minus.
Actual performance and specific performance, sir.
No minus. No minus, and each one is emboldened to answer.
General performance and specific performance.
No minus.
Actual and effective performance.
Actual and
Effective performance.
no minus.
Up to 14.
Specific performance, part performance.
No minus.
13.
Lateral and bilateral.
No.
14. Audience.
Sir, 2 types, sir. One is actual, second is constructive.
No actual and attempted performance. Section 37 of the Indian Contract Act. Section 37 of the Indian Contract Act recognizes two types of performance: actual performance and
ఎంత చెప్పు
attempted
మొత్తం
performance.
రికార్డింగ్లోనే ఉంచావు
16. So, continuing the same question, in section 38 it defines attempted performance, or otherwise known as a tender.
రికార్డ్ అవుతుంది లైవ్ కూడా అవుతుంది.
What is the meaning of attempted performance? What is the meaning of attempted performance? So section 37 says 2 types of performance: actual, attempted. And continuing it in 38, it says what is an attempted performance? Attempted performance is also otherwise known as a tender. What is it?
Pass.
Nagaleshwar garu leda? Marks istananu.
17. Pooja.
Yes.
As one party performs the promise, but the other party and the next.
No.
Minus.
No minus.
Okay.
How How attempted performance is defined in section 38 of the Indian Contract Act.
18.
How attempted performance is defined under the Indian Contract, under section 38 of the Indian Contract.
19. 1.
Minus 1. Minus
2.
One party has performed the obligation and other party didn't perform the obligation.
minus the basic law.
When one or more parties party to the contract are obligated to perform their duties and it is still left. When one party, which is the party to the contract, is obligated to perform certain duty and it is not actually committed.
No, minus. So my audience, sorry.
15 work. Audience.
Part of the answer. There is chala undi ka. When the promisor offers to perform his contractual obligations in accordance with the tenor of the contract at the same place, at the specified time, When the promisor offers to perform his contractual obligations as described in the contract, at the place chosen in the contract, at the time specified in the contract, and the promisee refuses, then it amounts to attempted performance. Then the liability of the promisor shall be discharged. Akkada moodu undali. Contractor he should discharge he should offer to perform his promise as per the tenor of the contract, at the place specified in the contract, at the time specified in the contract. So these three conditions must be satisfied. Then only it amounts to attempted performance. Yes. 17. We have a law of patent. So where the patent is given for 20 years. Okay. But in patent there is an important concept, that is evergreening. Evergreening. And every time there is a greenery. Okay. Evergreening is defined in section 3, subsection 1, clause D of the Patent Act. What do you mean by evergreening in patent law? What do you mean by evergreening in patent law? Next. What do you mean by evergreening in patent law? What do you mean by evergreening in patent law?
Patent always remains effective, operative.
What?
What patent always remains effective, operative. Always remains granted. There is no harm.
Minus.
Sir, with very minor changes in the technology, they claim for evergreening. It was defined in what is necessary.
Absolutely. So evergreening is nothing but before the expiry of the patent, some minute addition is added, and again patent is obtained for 20 more years, which is prohibited under the law. The Supreme Court in Novartis AG versus Union of India has prohibited the evergreening. Yes. 18. The question to team number 18. So under the Copyright Act 1957, we have a very innovative concept like fair dealing under section 52, fair dealing. In America it is known as fair practice. What do you understand by fair dealing? What do you understand by fair dealing under the Copyright Act 1957? 19. What do you understand by fair dealing? 1. Would you like to answer? Pass over.
Copyright person given consent with other person.
Minus.
Using of public works that are in public domain.
Minus.
Part of copyrighted work can be used for education purposes.
Alright.
A part of the copyrighted work can be used for education purposes. Comes under exemption.
With or without the consent? With the consent or without the consent?
With consent.
With consent, minus.
Without consent, fair dealing.
If anybody attempts then, if the answer is not exact as per section 52 of the Copyright Act, I will award the minus. If the answer is not as per the exact language used in section 52, then I will award minus. Yes, next.
Minus, sir.
No minus.
Sir, there is no need of any consent from the copyright, and there is also no infringement. For the purpose of research and education, they can use the copyrighted works.
Yes, right. So section 52 is recognizes fair dealing. It is a legal doctrine in copyright law that allows for a limited use of copyrighted material without the copyright of owners. Permission therefore not necessary. It is recognized under section 52 of the Copyright Act. Next.
19.
So under we have there is a very important enactment by name Right to Fair Compensation, Transparency in Land Acquisition, Rehabilitation and Resettlement Act. This act was brought into force due to the relentless struggle of the farmers. Okay, this act clearly says that if once the land was acquired by declaration, then if that land is not used for a minimum period of so and so years, then land should be given back to the farmer or should be credited to the land bank. How many years? So, the right to fair compensation, transparency in land acquisition, resettlement and rehabilitation act 2013. Suppose a land was taken from the farmer by declaration, but that land has not been used for the given purpose for a number of years. Then that land should be given back to the farmers after lapse of some period. What is that period? Yes, 5 years. 5 years. 5 years. Yes. Start with anti-clockwise. So we have so much. So for recreation we will release audios because there is some kind of boredom from your bases. So yes. So audio round, audio visual.
ఆడియో విజువల్స్ నేను తీసుకోనా కూర్చుంటారా
వద్దొద్దు
నాకు ఐడియా
Video చూపిస్తాం first.
పర్లేదు
Video.
I do think that outdoor costs music.
Dad used to work back then. I was so proud of all that. And now we thought, what's that crazy guy up to?
If we started talking about civic globalization instead of corporate globalization, the world would move forward.
Please look at him. Replay the video. One of the famous personality, popularly known as the father of American consumer movement,
I was so proud of all that.
who contested in the elections for 4 times and he got 30 million votes, 3 million votes, 30 lakh votes. Okay? Father of the American consumer movement. And he wrote a book. He wrote a famous book, Unlimited Speed at Any Cost, and he made the Ford company to cough up. So you see, the Ford company had released a car which was unsafe. Okay, it took many lives. So he said that the motor vehicle was defective. Ford company had made many defamatory statements against him, but he proved it before the American Congress. Okay, he studied law in Harvard Law School, and there was a film on his life. The name of the film is, if you have time, please look into the documentary. An Unreasonable Man. An Unreasonable Man. And he is recognized as one of the first 100 persons who have influenced the 20th century. Okay? He contested in the American elections 4 times.
I do think that outdoor costs music.
What is his name? Still he is alive. He is around 92 years of age. Still he is alive. Famous lawyer, famous consumer advocate, and father of American consumer movement. Who is he? What he does is, he engages a band of advocates and he works on public interest litigation. What is his name?
18, 17, 16, 15, 14, 13, 12, 11, 10, 9. Audience?
Yes, Ralph Nader. He is the Ralph Nader, a celebrity in his own life. A celebrity in his own life. Yes, Ralph Nader. You can also subscribe to his email. He regularly sends these articles. He regularly sends these articles on public interest matters. You too can take inspiration from him. It is Ralph Nader. Yes.
18. Next.
Slide. బొమ్మలే చూపిస్తాము ఫస్ట్. బొమ్మలే చూపించు. ఫిగర్స్ చూపించు. So, famous women, very outstanding women. Who are they? Next, who are they? Who are those women? What that photograph is about? What that photograph is about? Famous women, outstanding women.
Pass. 17.
Minus
17 above. Minus 1. 15, 14, 13, 12, 11, 10. Chapter 11.
Constituent Assembly members.
Right. They are the women members of the Constituent Assembly. They are the women members of the Constituent Assembly, right?
17.
Next. Who is that lady?
17.
Indira Gandhi.
Minus. Yes, Rajkumar Amurtha Kaur, member of the Constituent Assembly, the first Health Minister of India, and she was the initiator, founder of All India Institute of Medical Sciences. All India Institute of Medical Sciences. She was the one who started All India Institute of Medical Sciences. Yes.
16.
So this logo is a famous logo belonging to a famous organization. To which organization that logo belongs to? To which organization that logo belongs to? It is a logo of a famous organization. To which organization that logo belongs to? That is the logo of a famous organization. To which organization that logo belongs to?
Pass. Chapter. Pass.
Quick. అంటే ఎక్స్పాండ్ చేయమ్మా.
National Human Rights Commission.
Yes, right. National Human Rights Commission. So it is the logo of National Human Rights Commission. Yes.
15.
Clarity ka లేదు. So this is the drawing, this is the sketch that was originally drawn before a particular part of the Indian Constitution by Nandalal Bose and his team. Before which part this diagram was drawn? Before which part of the Indian Constitution this diagram was drawn? Before which part of the Indian Constitution this diagram was done, was drawn? Before.
Pass. Time 25 seconds completed.
ఈ డ్రాయింగ్స్ చివరిలో పెడదాం. డ్రాయింగ్స్ చివరిలో పెడదాం. ఏంటంటే ఈ డ్రాయింగ్స్. Yes. First, no. No.
Minus 1, 9.
What is the first?
Not first, not before first.
No, they are asking what is the question? Can you repeat
The
again?
question is, before which part of the Indian Constitution this picture, this drawing was made? Was it before 20th part or 19th part or 17th part? Which part? A particular part of the Indian Constitution begins with this drawing. In fact, every part begins with the drawing. The first of the Indian Constitution.
Part 4.
Minus. Part 3 minus.
19, 18, 17, 16. Audience.
Yes, part 2 right. Part 2 right. Thank you. Very good. I was very good. So this is a logo of a famous organization in India. This is a logo of a famous organization in India. What is the name of that organization? Logo of a famous organization in India.
Masa.
Right, expand it.
Authority of India.
Yes, National Legal Service Authority. Yes, right. Right.
13.
A famous lady, renowned lady, daring and dashing lady. Okay? And her contribution to the Indian law was outstanding. Who is she? She has the courage and the gut to take the matter to the Supreme Court for championing the cause of women. What is her name?
Mas.
Very famous lady. She was instrumental in bringing a change of law.
Mas.
Indra Swami.
Minus.
Zira Chase.
Minus. Minus.
18, 17, 16, 15, 14. Audience.
She is none other than Mary Roy, the mother of Arundhati Roy. Who filed the case Mary Roy versus Union of India, where Syrian Christian women were denied property rights, of the inheritance rights, and she took the matter to the Supreme Court because her father died and she was not allowed to claim share in the father's property except a claim of 5,000 rupees. She took the matter to the Supreme Court challenging it on the ground it is against the right to equality, and she won the case, and subsequently the Travancore Christian Act was abolished. Anand, Mary Roy, the mother of Arundhati Roy. The great woman who brought a sea change in promoting transparency and accountability in the Indian system. She was an IAS officer. She worked for 9 or 10 years. Later she came to the conclusion it is very difficult to bring about a change by working as IAS officer. She quit her job. She started a famous organization, Kisan Mazdoor Shakti Sangathan in Rajasthan. Okay? And she was the founder of RTI movement. It was she who first initiated the People's Movement for Right to Information. And she was also awarded with the Raman Magase Award She wrote her memoir by name Personal is Political. Okay? So what is her name? And she is one of the most, she was one of the 100 women who were most influential across the world. What is her name? What is her name?
Medha Patekar.
Minus. Minus.
19, 18, 17, 16, 15, 14, 13. Audience.
Yes, Aruna Roy. Aruna Roy is still alive. She is still alive. In fact, she was the one who first fought for people's right to information. Yes.
11.
See the gentleman, he is popularly known as the father of Indian environmental jurisprudence. He is popularly known as the father of Indian environmental jurisprudence. He was a forest officer. He was very sincere to the core. He filed a case before the Supreme Court. The Supreme Court in that case said that forest land, as per Forest Conservation Act 1980, would include not only the public forest land, but also the private forest land. So that is the reason why he is popularly described as the father of Indian environmental jurisprudence. What is the name? What is his name?
Pass.
No. Full name.
T.M. Godavarman Tirumalpad. Tirumalpad.
Tirumalpad. Right. So the name of the case is T.N. The name of that case is Tirumalpad. The name of that case is Godavarman Tirumalpad versus State of Tamil Nadu, where the Supreme Court held that the central government has the vast power under the Forest Conservation Act. Forest land would include not only the public forest land and private forest land. So no state government can convert them. No state government can convert the forest land for non-forest use unless until the permission of the central government was given. But unfortunately, the central government was diluting the judgment of the Supreme Court in this case. A famous judge, a very famous judge. He is not the judge of the Supreme Court, but he is the judge of the High Court. But he was responsible for most of the changes, for certain changes in India. What is his name? A famous judge.
Pass.
But he is not Supreme Court judge, he is only High Court judge. But yet,
up to 11. Audience.
no, minus. Who is he? Is none other than Mr. Sinha, who gave judgment in Indira Gandhi versus Rajanaran case, and which judgment led to imposition of emergency. High Court judge. Next.
9.
One of the famous judges, and he is responsible for pronouncing many trend-setting judgments. Okay, very simple man, And he said that I am an atheist. Perhaps the only judge of the Supreme Court who declared himself as atheist. At the same time respecting the religious sentiments of his wife. Who is he?
9.
Huh? No, minus. He is known for his erudite, progressive, trend-setting judgments.
19. 18. Up to 10. Audience.
So, audience, Justice Chinnappa Reddy of Andhra Pradesh. Justice Chinnappa Reddy of Andhra Pradesh, whose famous quote was, I mentioned at the beginning itself, our tradition teaches tolerance, our philosophy preaches tolerance, and our constitution practices tolerance. Because he who delivered judgment in Vijay Misra case. Vijay Emmanuel. Next.
8.
Atisema. So this diagram appears before a particular part of the Indian Constitution. This diagram appears before a particular part of the Indian Constitution drawn by Nandalal Bose. Before which part it appears? Sorry, the question is cancelled.
8 again. 8.
Very good, Uddama. Very good. So this diagram appears before which part of the Indian Constitution?
8.
This diagram appears before which part of the Indian Constitution? Anyone?
9. Up to 9. Audience.
Part 10. Next.
7.
So Lord Buddha, Lord Buddha with his disciples, this diagram appears before which part of the Indian Constitution?
7. Pass. Up to 8. 8 work. Audience.
Part? Yes, part 5, right. Part 5, right. Part 5, yes, right.
6.
So Lord Nataraja. So this diagram appears before which part of the Indian Constitution? Lord Nataraja.
6. Pass.
12.
Yes, part 12, right. Part 12. Part 12, yes, right.
5.
Next. So this diagram appears before an important part of the Indian Constitution. With mountains, environment, before which part it appears? Minus part 1, not part 1. Audience? Sorry. Double minus.
Up to 6.
Part 20, dealing with amendment to the Constitution.
4.
Next 4. 4, again, we are skipping these pictorial diagrams. So we have a Design Act. Okay, you are quite aware of the Design Act 2000. Under the Design Act 2000, if a particular design is registered, then it is the protection will be given to the designer for a particular period, and again it can be re-registered. What is the maximum period for which protection is given to the designer owner? What is the maximum period of protection that is given to the registered owner of the designer? What is the maximum period? I'm asking maximum period. You are saying limited period. Minus.
ఐదు వరకు వెళ్ళచ్చు
10 plus 5 years.
Right, 10 plus 5. 10 plus 5, right.
3.
So, there are grave apprehensions regarding climate change. Okay. So, climate is fast changing and appears. The United Nations Environmental Committee says that even mankind may extinct due to anthropogenic activities. The Paris Accord is one of the famous United Nations initiated agreement on limiting the rise in temperatures. Okay. So my question is, the Paris Accord on climate change has committed to limit the rise in temperatures to a particular limit above the industrial age. What is that limit? The Paris Accord on climate change has committed to limit the rise in global temperatures to a particular limit above the industrial age. What is that limit? What is that limit?
2, 1, 19.
What is that limit?
18.
What is that limit agreed upon by the Paris Accord? The Paris Accord on climate change.
Move up to 4.
1.5 from 2030.
1.5
from 2030 levels. And by 20.
Answer is partially correct. No minus. 1.5 2030 only.
1.5, sir, but
You have not understood my question also. What I am asking, the Paris Accord has committed to limit the temperature rise to a particular limit from the above the industrial age. Above the industrial age. So, from industrial age to the present, what is that commitment? That is what I am asking. No minus.
Pass.
1.5 from which age? From which period? Huh? You are not okay. No minus.
Audience.
I am repeating the question once again. The Paris Accord on climate change has committed to limit the hike or rise in enhancement in temperature to a particular limit above the industrial age. Above the industrial age. What is that limit?
25 years.
Audience. Huh? Below 2 degrees. That's 1.5. 1.5 from industrial age, not from 2030. 1.5 from the industrial age. Yes, right. Correct. Yes. Next. So in medical negligence, we have a famous test that was introduced by the House of Lords in England, and the test is also incorporated into Indian legal system. The test was also recognized by the Supreme Court. The test is popularly known as the Bolam test. What is Bolam test? What is Bolam test? What exactly it is? What is Bolam test? B-O-L-E-M. What is Bolam test?
1, 19.
What is Bolam test? What is test of Bolam, which is popularly applied in medical negligence cases, though it has been slightly modified nowadays. Slightly, it has not been replaced. What is Bolam test?
3 word. Stop. Audience.
Audience. Pardon, sir? No. A Bolam test. No, that's not. A Bolam test is a test when there are two alternate procedures to be applied by a doctor to the given situation of the patient. If the particular practice adopted by the doctor is recognized by a reasonable number of medical professionals or by a responsible number of medical professionals, then it is not medical negligence. That means myself being a doctor, I have followed a particular procedure, but there are different procedures. I have followed a particular procedure. That procedure is recognized by a responsible body of medical professionals. Though in the given situation, other procedure can also be employed, even then I am not negligent. That is what is meant by Bolam test. Next. Okay. So question 3.1. Yes. The Competition Act 2002 replaced the MRTP Act, but the Competition Act was enacted based on the recommendations of a particular committee. What is the name of that committee? The Competition Act 2002 was enacted based on the recommendations of an expert committee. What is the name of that expert committee? That committee is named after the name of its chairman. Okay? What is the name of that committee? What is the name of that committee?
2, 3.
Pardon? Yes?
SVS Raghavan Committee.
Absolutely. SVS Raghavan Committee. Right. 2. Number 2. Again, to question number 2 from the Competition Act. What is a cartel? What is a cartel? C-A-R-T-L. What is a cartel?
Group of a common interest people. Group of a common interest people or similar kind of people doing the same thing, business or something. I want to elaborate. If I am a
For example, I manufacture a bulb, and there are many people who manufacture bulbs. We all make a team. That's the part, cartel. That phenomenon is cartel.
Your answer is not full, your answer is partial. Next. No minus.
A group of similar associations when they agree to control the prices or the market, it is defined under section 2C of the Competition Act.
Right. A cartel is a group of producers or manufacturers in the same field, either for restricting the demand to artificially jack up the price or to fleece the consumers. Okay, yes.
3.
Next. Question to team number 3. So there is the government has invoked a sedition against many people, including Vinod Dua, the journalist. Okay, where the Supreme Court said that the provision of sedition was invoked against Mahatma Gandhi, Bal Gangadhar Tilak. So many people. So the Supreme Court said that you put that in abeyance. But the BNS contained the provisions relating to sedition in more stringent form. In which section? Which section of the BNS contains the provisions pertaining to sedition in more stringent form? Name the section.
Pass.
121.
121, no.
121 to 123.
No.
Minus.
152. Yes, 152 of the BNS, right.
4.
4. In international law, we have a concept. The concept is popularly known as non-refoulement. N-O-N, non, R-E-F-O-U-L-E-M-E-N-T, non-refoulement. It is a concept. This concept was recently derogatorily rejected by the Supreme Court, saying what is this? So what do you mean by non-refoulement?
4. 5.
Yes.
Sir, not sending back the citizens to other country to protect their rights.
Who are the citizens?
Not citizens, sir. When they come from the other country to this country, again if you want to send them to the other country, but their laws are their rights are getting violated. So to protect them, the country protects these citizens in this country, not sending them back to their country.
Yes, right. Non-refoulement is an important principle in international law where refugees are not sent, refugees or asylum seekers are not sent to the country of their origin because of persecution. Supreme Court recently passed some remarks against Rohingyas. Okay? Yes.
Right.
Next. Again, a popular term in law, which you find in many Supreme Court judgments, saying that, what do you mean by res integra? Supreme Court says, it is no more a res integra. If you read the original judgments, you will find this word. What is res integra? What is a res integra? If you read the original text of judgments, you will find this word very often. What is meant by res integra?
Pass. Pass.
What is res integra?
1, 2, 3, 4. Audience.
Audience? Yes, right, untouched matter. So res integra is a Latin legal term meaning an untouched thing or an entirely new or untouched matter, or it is a matter of first impression. Like, for example, say for example, if any liability in regard to generative artificial intelligence comes, it is definitely res integra. Okay, next.
6.
6. So in which of the famous cases Lord Atkin has come out with the famous principle of famous principle known as Neighbor's principle. Neighbor's principle. What is the name of that case? Neighbor's principle. In which of the famous cases the House of Lords, speaking through Lord Atkin, has come out with Neighbor's principle?
Donkey versus Stevenson.
Stevenson.
Huh?
Donkey versus Stevenson.
Spell it properly.
Donkey versus Stevenson.
Yes, right. Right.
7.
Next. Wrong versus Stevenson. Next.
7.
7. We have different kinds of marriages under Hindu law. So being the citizens of this great country, we must be aware of our history also. What do you mean by Anuloma and Pratiloma marriages? What do you should answer both of them. What do you mean by Anuloma and Pratiloma marriages? What do you mean by Anuloma and Pratiloma marriages?
It refers to lawful and unlawful marriages.
Minus.
When the bride is of the higher caste.
So you should give correct answer, otherwise you give minus. Because if you speak something, then others will get the cue. That is the problem. Okay? You should give, if you are certain, then answer. Otherwise you give minus.
The bride is of the higher caste than the duo. It is called as a Anuloma marriage. And
Bride.
Yes.
Bride. Minus.
These are a type of marriages where when it comes to Anuloma, bridegroom is from higher caste and bride is from lower caste. And when it comes to Pratiloma, bridegroom is from lower caste and bride is from the higher caste. Seven. These are the type of marriages where when it comes to Anuloma, bridegroom is from higher caste, bride is from lower caste. When it comes to Pratiloma, bridegroom is from lower caste, bride is from higher caste.
Right. So according to Manu and Hindu Dharma Shastras, Anuloma marriage is permissible, whereas Pratiloma marriage is not permissible. Okay? Yes. 8. Question to team number 8. So, I am the author of a renowned book. So I have copyright protection. For how many years I enjoy copyright protection? What is the period of copyright protection under the Copyright Act?
20. 20.
Minus.
The lifetime of the author plus 60 years.
Yes, right. Lifetime of the author and 60 years. Yes. 9. Who is a persona non grata? Who is a persona non grata? It is also a legal term. Who is a persona non grata? If you have the habit of reading newspapers, then you will find this word very often. Who is a persona non grata?
Pass.
Who is a persona non grata?
17, 18, 19, 1. Up to 8. Stop. Audience.
A persona non grata is a Latin phrase meaning an unwelcome person most often used in diplomacy to refer to a foreign diplomat whom a host country asks him to leave. So this declaration means that the person is no longer welcome and must depart the country. Okay? Next. Next question to team number 10. Team number 10. Who is a pro forma defendant? Very often, who is a pro forma defendant? Who is a pro forma defendant? Who is a pro forma defendant? Who is a pro forma defendant?
Sir, a non-party to the suit.
A non-party to the suit. Minus
Up to 9.
A defendant against whom no claim is made.
a defendant.
Against whom no claim is made.
No claim is made, but
He is a party to the suit.
right. A defendant who may be linked to the cause of action, who is made as a party, but against whom no relief is claimed, then he or she is known as a pro forma defendant. Right.
11.
Now question to team number 11. What is the period of limitation for filing a consumer case in Consumer Disputes Redressal Commissions at the district level?
State level.
At the district level.
2 years. 2 years.
It's 2 years. 2 years. Next. Right, they have given right answer.
12.
So section 45 of the Insurance Act says, even if the insured commits fraud, forgery, but if the insured pays premium for minimum of certain years, then the insurer is liable. Then the insurer cannot say insured is guilty of fraud. Those kind of defenses are not available. In fact, every insurance policy must contain the exact words of section 45. You please go back to home, you check insurance policy subscribed by your father or mother. You will contain section 45 in prominent words saying, so an insurance policy, when premium is paid for a minimum of certain years, then the insurer cannot avoid its liability. How many years? How many years? How many years? Even though there is fraud, even though there is forgery, yet the insurer is liable. How many years? Right. Previously, it was 2 years. The Insurance Amendment Act 2014 has enhanced it to 3 years.
13.
Previously, fraud can be proved, but now it cannot be alleged at all. Next.
13.
Again, referring to insurance contracts, what is the cooling period in an insurance contract? What is a cooling period in an insurance contract? What is a cooling period in a contract of insurance? What is the cooling period?
Pass. 50. 60.
30 days.
30?
30 days.
Now, what is it? Your answer is correct. What is it? What is the cooling period? No minus. What is it? What is it?
It's like a grace.
Now, what is it? What effect it has? Your answer is correct.
You can take
Huh? You can take what? No minus. Yes.
17. 18. 19. 1.
30 days. నేను అడిగింది what is it and I am not asking what is the cooling period in insurance contract in my question.
Take back the policy.
Huh?
You can take back the policy.
Take back and what do you mean by take back? Yes, yes, right. The cooling period varies from 15 to 30 days, during which period the insured has a choice of cancelling the coming out of the contract by claiming back the money, subject to minimum charge, deduction of charges. Next.
14.
Next. Next. What is the pecuniary jurisdiction of the National Commission? National Consumer Disputes Redressal Commission. What is the pecuniary jurisdiction of National Consumer Disputes Redressal Commission?
Pass. 15.
10 crores and above. Above 10 crores. 10 crores and above.
No minus.
Exceeding 10 crores.
No minus, but subsequently it was reduced. No minus. You are giving the original enact. No minus.
17.
Subsequently it was reduced.
18.
Subsequently it was reduced.
19. 1.
Minus.
Seven.
2 crores, sir.
Who said it?
2 crores.
2 crores, sir?
Sir,
No minus. No, సరిగా చెప్పు answer.
less than 2 crores.
2 crores అయితే?
Sir, pardon?
Exactly 2 crores or less than 2 crores.
Your answer should be appropriate.
Sir, could you please repeat the question, sir?
What is the pecuniary jurisdiction of National Commission అంటే ఎక్కడి నుంచి స్టార్ట్ అవుతుంది ఎక్కడితో ఎండ్ అవుతుంది అది కావున్నాం.
Okay.
That is what sorry I am
It
asking.
starts from 2 crores, sir.
Starts from 2 crores. Goes up to
Goes up to National Commission means
goes up to what amount? 100 crores, 200 crores ఏమన్నా?
no limit, sir. No limit.
No limit.
From 2 crores it starts in the national.
Suppose if it is exactly 2 crores, where you have to find?
2 crores and above is national, sir. I mean 2.
No man. This question is cancelled. above 2 crores. 2 crores low 2 crores అయితే 2 crores కూడా state commission. If it is 2 crores, state commission. Above and no upper ceiling.
14.
Yes. Next. Next.
14.
What is an escrow? What is an escrow? Escrow under the MI Act. ESCRO. What is an escrow under the Negotiable Instruments Act? What is an escrow under the Negotiable Instruments Act? What is an escrow under the Negotiable Instruments Act?
Pass.
Sir, it is not given as a negotiation, but it can be taken as a demand. Like if we give first custody, sir, if we give an instrument for custody, again we can take back, and not for the negotiation.
Yes, right. An escrow is a negotiable instrument which is given for a specific purpose of custody or safe custody or for based on condition. Okay, next. Condition delivery. Next. So section 17 of the MI Act deals with an ambiguous instrument. An ambiguous instrument. What according to you is an ambiguous instrument under the law? Section 17 of the MI Act deals with an ambiguous instrument. What according to you is an ambiguous instrument? Yes.
Which is unclear, sir.
No minus, but you should provide a clear answer. Ambiguous is a dictionary meaning itself is unclear.
No, sir. Instrument,
What is an ambiguous instrument? I am asking no minus.
like a certain amount not mentioned properly and signature.
No, no minus. What is an ambiguous? What exactly it is?
17, 18, 19, 1, up to 14.
Where the numbered amount is different from the words amount. The amount
No
which is
minus,
specified.
no minus, you are not giving proper answer. That is part of it, part of the answer. Ambiguous instrument has a wider meaning under section 17. Please go back to home and check it.
Up to 14.
When the drawee is also not known, and when there is a
No.
Minus.
No minus.
14. Audience.
Proper, correct, partly. So an ambiguous instrument according to section 17 is an instrument which owing to its faulty drafting could either be treated as a promissory note or as a bill of exchange, and it also includes an instrument where there is a difference between the amount stated in words and figures. So it has a wider meaning. Okay, next. What is it? Next, what is an inchoate instrument under the NI Act?
Inchoate instrument is an incomplete instrument without the signature, without filling any amount, sir. It is implied to the payee to write anything he wants.
Section 20 of the NI
Implied
Act.
version.
Section 20 of the NI Act deals with an inchoate instrument. An inchoate instrument is an incomplete instrument signed, but it applies to only instruments requiring stamp. There cannot be an inchoate check, but there can be an inchoate promissory note and inchoate bill of exchange. Next. So we have Registration Act 1908. Under the Registration Act, once the parties execute the document, but it can be submitted for registration within a prescribed time. What is that time? As per section 23 of the Registration Act says, when a document was executed other than will, then it can be presented for registration, though there is a time lapse within a prescribed time. What is the total length of the period? Minus 1. Yes.
Up to 16. Audience.
90 days. No, 120 days. Refer to 4 months. 4 months. Okay, next. So in international law, we have different theories of recognition. We have facultative theory of recognition. Facultative theory of recognition. What does it mean? What do you mean by facultative theory of recognition? What do you mean by facultative theory of recognition?
30, 1,
What do you mean by facultative theory of recognition? We have de facto, de jure, those are modes of recognition. I am not asking about them. What do you mean by facultative theory of recognition?
Public international law.
Huh?
Under public international law.
Yes, from the public intervention.
up to 17. 17 1.
facultative theory of recognition, he says that there are no binding rules in regard to recognition. Recognition is purely and simply a political act, depending on the political expediency. Okay? Depending on the political expediency. Next. 19. So there is a famous jurist under jurisprudence who said every law should be tested on the touchstone of social solidarity. The purpose of law is to promote social solidarity. If a rule fails to promote social solidarity, then it is not law. Who is it? Who is it? So according to him, every law should be tested on the touchstone of social solidarity. According to him, the world we are living in is interdependent. No man can live on his own. Every man is dependent for his needs and services upon the fellow human beings. Therefore, law should promote, sustain and support social solidarity. Who is he? అసలు ఒక ర్యాపిడ్ రౌండ్ ఉందండి, డబ్బు అయిపోయింది. ఒక ర్యాపిడ్ లాస్ట్ రౌండ్.
possibility of tie after finalization of the scores, there is a tiebreaker. That's why I am requesting you to stay back 10 more minutes until completion of the scoreboard. And immediately after completion of this event, dinner is already ready. I request all audience and participants move on to the hall to have your dinner. Please stay back 10 more minutes. Persons in the Moot Hall. That's why we are planning to give live telecast here itself, and others may watch from here also. Okay, please stay back.